Good evening. It's 5:30-ish on Wednesday, October 8th, 2014. It's the monthly meeting of the Urbana Human Relations Commission. Could we please have a roll call?
Francis Rigberg Baker,
Here.
Kevin Bowersox Johnson,
Here.
Daniel Larson,
Here.
Lisa Mosley,
Here.
Peter Resnick,
Here.
and Aisha Lam Sobe.
Thank you. Looking over the agenda, are there any edits, additions, corrections that need to be made? If not, is there a motion to approve?
I motion to approve. Sorry.
I'll second.
Thank you. All those in favor, please say aye.
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 Opposed, the same. Also, we have an approval of both our August and September minutes. Are there any edits, corrections, additions that need to be made? If not, is there a motion to approve?
I move approval of the minutes.
Thank you.
I second.
All those in favor, please say aye.
Aye.
Opposed, the same. Public participation? Thank you. Old business. Todd, we got a slate. Get us started, please.
So I guess I was of the mind that perhaps we could go over in a very brief fashion the presentation from last meeting, just because we had so few people here, and it will provide at least a minimum context for the later discussion that we're going to have. Is that agreeable to everyone? Okay, I see shaking heads. So this is a discussion of the newly passed, it was passed back in July, the Illinois Job Opportunities for Qualified Applicants Act and the Urbana Human Relations Office's prior conviction enforcement rule. What I'd like to do today is summarize the act, explore the interaction between the act and our enforcement rule, review the key distinctions between the act and our enforcement rule, and then to discuss the educational proposal and the legal analysis that we've done in the intervening weeks since the last meeting. So as you have questions, please feel free to interrupt me and just ask away. So the Illinois Job Opportunities and Qualifications Act, Applicants Act, was passed on July 19, 2014, or it was signed by the governor then. It will be effective January 1st, 2015. It affects private sector employers that employ 15 or more employees. It covers employers, or covered employers may not inquire into or require disclosure of an applicant's criminal background until the applicant has been determined to be qualified and selected for interview or conditional offer of employment. That should sound really familiar. The exceptions to that rule are employers who are required to exclude applicants with specific convictions under state and federal law. That should also sound pretty familiar. Where the position has a fidelity bonding requirement and the applicant's conviction is specified as a disqualifying element of that bonding. And finally, employers who hire individuals under the Emergency Medical Services Systems Act. Any questions there? All right. So one of the things I wanted to note, because this is a key distinction, the Act does not prevent employers from notifying applicants in writing of the specific offenses that will disqualify an applicant from the employment in a particular position due to the federal or state law or the employer's policy. And that's going to be really important, that employer's policy, in sort of drawing a distinction between our enforcement rule and more specifically our ordinance in the Act. And the enforcement is charged, or the enforcement will be handled by the Illinois Department of Labor, and they will propagate administrative rules as they deem necessary. The penalties: for first violation, you receive a written warning with 30 days to correct. Second violation, or if you fail to correct in that 30 days, you receive a civil penalty of up to $500. Third violation, or if you refuse to correct the first and the second violations, then you receive a civil penalty up to $1,500, and subsequent violations will incur a $1,500 per 30-day period fee for a continual noncompliance. So, just a reminder, the ordinance, the Urbana Human Rights Ordinance, bars employers, landlords, anyone who's offering covered opportunities from denying individuals those opportunities strictly based upon their prior conviction. And it also prohibits employers from using written or oral or inquiring in writing or orally with an intent to discriminate. It also prohibits employers from indicating that they have a discriminatory preference, limitation, or specification in job advertisements. And very sort of importantly, it creates an exception for practices that are reasonably necessary for the normal operation of business. And so you know all of this. It's been around since 1975. The guidance that we've issued or the rule that we've issued does not change or modify any existing law. It just explains how we will view the law. And most importantly, the operative effect of that is that what we were saying is that employers can no longer require applicants to reveal whether or not they have a prior conviction in the early stages of the application process. And then there's the caveat that employers may, in some instances, deny employment when they can affirmatively establish that such denial is reasonably necessary to the normal operation of their business or enterprise. And again, they can only ask once they've gotten to the point of making a conditional offer of employment. So, key distinctions. So, the state act mandates a process, right? But it does not speak to, once you perform the criminal background check, it doesn't limit the employer's decision. So the employer, under the state act, could have a policy where they don't employ anyone with a felony conviction or anyone with any other type of conviction, whether or not it has anything to do with the position applied for. It only regulates the process and the timing at which that question can be asked. It doesn't address different types of factors that we've talked about in doing the individual assessment. It doesn't do any of that. The Human Relations or the Human Rights Ordinance, on the other hand, does address that. And in fact, it substantively addresses that and says that the only time that you can deny someone employment based upon that prior conviction is when it is reasonably necessary for the normal operation of business. One of the key things I pointed out last month is that the big criticism of the enforcement rule was that employers in Urbana would have to change their applications to conform with the rule, and that would have a hardship on multi-site employers. So, for instance, if I've got, sites all over the state of Illinois or even all over the country, I would have to change my job application for Urbana to comply with Urbana, and that seemed to be very onerous. Well, by virtue of the state law, because the state law is now prohibiting that, I think that argument has much less validity and power, because whether or not Urbana ever would require that the applications be changed, it appears as if the state law is saying you can't inquire at that application point. So in order to be consistent with state law, they will now have to do the same thing that they would have had to have done as a result of the Urbana's enforcement rule. Does that make sense to everybody? One of the key differences here is that the state rule only applies to employers that are 15 and more employees, whereas the ordinance applies to every employer, regardless of size. And so as a result of that, we were asking the question because that seems to be somewhat in conflict. The other conflict is whether or not, so there are exceptions that are made for employers who are prohibited by state or federal law from employing people with certain criminal convictions for certain positions, right? And we've talked about the Illinois Healthcare Background Check Workers Act, right? That says if you have these key positions working for you, then you can't employ people with these particular backgrounds because you have a compromised population. In the state law, the state seems to be saying that if you're an employer, and let's say you have 100 positions, and 20 of those positions involve those that are regulated by state or federal law that contain those exclusions, then the employer is therefore exempted from complying with the act. Does that make sense? Whereas the enforcement rule was written so that if you have those 20 positions, and well, the 20 positions would be exempted, but the remaining 80 or the balance of 80 you would still have to not make those inquiries pre-employment or pre-offer of employment. Does that make sense? So those are the two key distinctions that we could find between the state act and the enforcement rule. I'm just going to sort of move ahead here. So I made two recommendations last month. The first one is that we undertake a pretty substantial educational campaign to educate local citizens and local businesses about the state law, about the enforcement rule, and about the substantive requirements of the ordinance itself. Because what I anticipate, the way that it's handled now, and the reason that the rule was so important to begin with is that if an individual feels like if they go and apply, let's say at a local business for a job, and they have a criminal background, and they go ahead and make application for the position, and they don't get a call for an interview, right? They have very little basis or way of knowing whether or not their criminal background and the disclosure on that application in any way affected that decision. It could be one of a myriad of different reasons. Well, when you say that the only time that you can check criminal background is after a conditional offer of employment has been made, then what you're effectively saying is that you're taking the person through the entire application process and basically saying you're qualified. In fact, you're the top candidate for this position, so now we're going to run a conditional background check on you. And when that background check comes back, it is clear, if you're denied employment at that point, it is clear that criminal background had something to do with, or at least it's very likely that it had something to do with you not receiving the ultimate employment after receiving a conditional offer of employment. So as a result of that, we felt that the enforcement rule would really bring to light many of the cases that we're not currently seeing. For instance, the way that the law is currently enforced, if an employer just wanted to go through their applications at the very first stage of the process and just weed out all of the ones that checked yes to criminal background and throw them in the shredder, there's really nothing in terms of the way that we're enforcing it now. There would be very little by means of detecting that type of activity. All right? Well, now under the enforcement rule, and maybe even more importantly under state law, that type of activity would be prohibited for all except for the cases of exemptions that we've seen. And again, what that will do is that will raise our ability to detect when those types of violations are occurring. And so I thought it would be important for us to undertake an extensive educational campaign to let everyone in the city of Urbana, the residents and the businesses, sort of know how these two rules interact, how these two regulations interact, and how it may affect their business, how it may affect applicants who are applying for positions. I remember the last time that we did a workshop, an expungement workshop, right? We filled up a large room at the Urbana Civic Center with people who just wanted to know how they could undergo some type of process that would reduce the negative impact of their conviction on their employment prospects through expungement or through some other type of process. And so I would imagine that there are many people who will be very, very interested in the state law and also in the rule, and also how it interacts with our existing ordinance. And then we also recommended that we request that the legal division provide some guidance as to whether or not in those areas of conflict, so the 15 or more employees and the positions versus employers, whether or not that there would be any problem with enforcing that as the city when you have a state law that has been passed that addresses very similar, if not the exact same issues. And so I just wanted to provide the results of that. So the educational campaign is not particularly, I don't want to say it's not interesting, but it's basically we would have 2 or 3 workshops in the month of November and December, most likely at the Urbana Civic Center, where we would try to get some state official from the Illinois Department of Labor to come in and present about the act. We would present about the ordinance, and then we would take questions. So that seems pretty straightforward. So I'm not going to spend a lot of time on that. Any questions on that before I leave it? All right. So now we get to the legal opinion. So you all have received a memo, and I apologize for the many versions of the memo. I think I edited and sent out the wrong version the first time, and then we tried to correct it the second, and now you have a version in front of you, which is the true version, or at least the truer version. I guess all of these works are sort of works in progress. And I just sort of want to reiterate, so the 2 areas of consistency are the coverage for employers with less than 15 employees and coverage for employers that are prohibited from hiring individuals with certain convictions by state or federal law. Yes?
So I think I'm going to ask for you to go ask Michelle to review. I'm looking at the Public Act online, and there's at least an ambiguity, and I read it as the second inconsistency isn't really there. And I want to be convinced one way or the other, because the way it's worded is it says the requirements set forth in subsection A of this section do not apply for positions where the employers are required to exclude applicants with certain criminal convictions.
Yeah, I think the overall reading, and I can sort of go over that with you, I think the overall reading of the way the act flows, it looks as if the employers are exempted. But we can look at that.
I'm curious because it does use the word positions in there.
Yes, it does.
In the right place to make it seem like it's about the exclusion.
The exclusions and the exemptions are about the positions without question. The question is whether or not that ultimately exempts the employer or the position itself.
And so, the other thing is, as you do this presentation for other folks, you should probably point out there's a third inconsistency, which is the fact that you have to have for the ordinance a reason, all right, a business.
That's not really an inconsistency. The state law.
It's just an additional bit.
Yeah, the state law governs the process and the timing. It doesn't
say what you do.
Yeah, what to do, how the decision, the factors that can go into the decision. And we sort of covered that before, but I'll make sure to emphasize
okay,
that.
so you're viewing it as sort of 2 separate things. One is there are these things where we actually have
Direct
different standards,
inconsistencies, yes.
right? And the other is we've got this additional standard,
Right, because
on
that
top
just
of it.
doesn't exist in that part of the. It's not inconsistent because it's not. That's not what they're trying to do.
And as far as we can tell, the stuff about the administration and rulemaking is not going to change that fact. That the Department of Labor is not going to be able to say.
They can't. Well, I won't say that they can't, but I think it would require a state law in order to include prior conviction as a protected class or
All right.
criminal conviction or something like that. I would be really surprised if they tried to do that through administrative rulemaking.
Okay, no, that seems reasonable. Okay, thanks.
All right, so for now, we'll at least proceed with under the assumption that there are 2 conflicts. Yes, ma'am.
Another possible conflict, it seems to me, is discussing the point at which you can do this criminal background check. And we say it's at a certain point when an offer is tendered, but in the, it seems to me in the act, it says, until the applicant has been determined to be qualified for a given position, selected for interview,
Right.
or given a conditional offer of employment. Selected for interview is very different
Yes.
from offering
and
employment.
And maybe when
seems
I
to
was
me.
viewing this, I was viewing this kind of as an HR person. To be quite honest with you, in terms of enforcement, it really will make very little difference, because if you're selected for an interview, you're deemed to have met the minimum qualifications. And to,
But you might not, I'm sorry, but I think what Fran's saying is, but you might not be making a conditional offer. So I might-
Absolutely.
So the inconsistency is,
Right.
I could do the interview, not make the conditional offer, do the background check, then decide whether to make the conditional offer or not.
right. And so I guess when I was reviewing that seemed, obviously it is a distinction, there is a difference. I'm not exactly sure in terms of operationally how much of a it's a big deal if I'm an employer who otherwise would not be covered and otherwise wouldn't have to do something, and now I have to do it. The point in the process where it actually occurs, I think there can be some arguments over inconsistencies there, but I think probably that we're much less likely to receive a challenge in that area than we are in these other areas. But that's just sort of an opinion.
It just doesn't isolate that as much as our ordinance.
Right,
does.
no, it
Yeah.
definitely, it is different.
I think it's much harder to prove. I mean, the reality is, if you're offered an interview, you're interviewed, but a conditional offer hasn't been made, there's, again, that ambiguity that was there before of, did I not get the job because I had a poor interview, or did I not get the job because of my background? And I think, again, we're back to that, what is the reason why I'm not getting the job? Whereas, in a process that says you can only conduct the check after a conditional offer is met, you know for a fact that if you did not get the job, that they will then tell you, we have to rescind our offer, or it was a conditional offer and it's no longer an offer because you failed the background check, versus your hands are in the air because you can't prove whether it was a bad interview, they just didn't, they weren't as qualified as you thought they were, or they conducted a background check, found information, and used that information, but now you can't prove it.
Well, I guess what I would say is that it is the difference between having no real fact-finding, right? In the case of a conditional offer of employment, you don't really have to have fact-finding because the facts speak for themselves. You've offered the conditional offer of employment because this is the most qualified candidate, exempting the fact that they have this criminal background, right? With the interview, you're absolutely right. It is more difficult, right? You will have to engage in fact-finding. In terms of investigations through my office, though, if we get all those in, that's fine, because even those don't come anywhere close to the type of fact-specific scenarios that we deal with in other cases. And so we can compare applications, we can compare interview notes, and we can go in and detect those types of issues. But I see your point, and we can include that as a possible area of inconsistency.
I'd like to add that interviews are points in the process where it's very easy for all kinds of discrimination to kick in, and some can be avoided and some cannot. It's also, I believe, notoriously not a good predictor of how people do. I wouldn't mind seeing interviews go away, but as it is, I'm happy that we at least acknowledge that this is a possible issue.
So yeah, we'll think about those interviews and what that difference may mean in terms of, from a legal standpoint, and also from a term of an enforcement standpoint, what that really will mean on the ground.
And I think this goes to Kevin's point, which I think is exactly right, but if an employer is inclined to discriminate, they just say, look, I don't care what the ordinance is, I have absolutely no intention of hiring anyone with a criminal background. There are two exceptions in the state law that allow them to get away with that. One is that, of course, they can do the criminal background check and then decide that the criteria is whatever it is. But the other is, in this interview case, that if they go in saying, that's what I'm going to do, then what they do is they will make a point of, I'm going to do the interview, I'm going to do the criminal background check, and if the criminal background check comes back bad, if I want to avoid any question, I put in the interview notes after the fact, this person did not seem to be a good fit with the team, and you're done. The fact finding is over.
I'm not
and
exactly
done with.
sure you're done at that point.
Maybe.
Yeah, it
But
just
I think
depends.
there are just so many ways to be, as Kevin put it, that you come out of that process with a much higher burden of having to prove that you were discriminated against, because there are many more ways to make the interview notes appear as if you found that the interview was the problem, than the case where if they make the conditional offer, it's very straightforward to tell what exactly happened. There's no fact-finding to be done.
Right.
So, yeah, I agree with Fran. This should be pointed out.
Any other comments about that sort of particular point? Okay, so basically preemption, as I understand it, as a layperson, is a doctrine that would invalidate a law, the law of a subordinate political unit, city, when it is inconsistent and of the same subject matter as a superior political unit, such as the state. Conflict is a very, in my mind, they seem to be very close in terms of what they are saying. A doctrine that would invalidate a local law when its provisions are deemed to be repugnant or contrary to state law. And so, let's go on. So, what we were able to, or at least what we concluded in thinking about this and talking about this, is that a legal challenge may arise from one of the two, either the fact that we will end up enforcing this rule with an employer that has less than 15 employees, or the rule with an employer that has certain positions that are exempted that by state or federal law, but the employer itself is not exempted. The recent rulings, based upon Michelle's reading, tend to conflate preemption and conflict. There traditionally are two different ways, two different tests that would be applied to determine. There's one for preemption and one for conflict. They tend to sort of talk about them interchangeably, and one right after the other, and it's very difficult to sort of discern which one they're talking about at any particular point. However, the takeaway from those rulings is that the courts seem to feel that if the legislature wants a state law to preempt local laws, a local home rule unit law, then they need to say it expressly. And there is no express provision that we found in the act that would preempt local laws. That said, that is a marked departure from sort of longstanding precedent. And when that happens, you tend to think that at some point on the right case, there may be some reversal, right? As it is, bad cases, hard cases make bad law. So even though we can pretty confidently say, based upon the reading, that, yeah, you're really looking for express articulation of preemption, we're not overwhelmingly confident that will happen. And I want to bring a scenario before you. So let's just say you've got a small employer, 3 or 4 employees, right, and an owner, operator, who has decided that they don't have the expertise or the means in order to interview candidates and review candidates and do a recruitment process for candidates and bring everyone through the process all the way to the conditional point of hire and then do their criminal background check. So they decide, look, we need to do that in the beginning because we just don't have the capacity, the resources, we don't have the whatever it is that we would need in order to do, in order to go through this process with everybody, because everyone who we go through the process with costs us money and it costs us time. We don't have the time to do that, so we're going to weed out individuals with certain criminal convictions earlier in the process, right, than we would allow in our enforcement rule. So we go and we enforce the rule against them, and we say, at this point, you are now prohibited from in making this inquiry earlier in the process than what we have in our rule, because that would be a violation of the ordinance. And then that employer says, yeah, I don't like that ruling, so I'm going to challenge that ruling. I'm not exactly sure, well, I think that presents a compelling question, because in looking at the issues, the state obviously had the option to include less than 15, or employers with less than 15 employees. And for some reason, and I haven't looked at the legislative history, but for some reason they chose not to include those businesses. And if the argument was brought up that, you know, the state chose specifically not to regulate in this area or not to require these employers to have that administrative burden based upon their size, that seems to me something that may give some decision makers pause. And so while like I said, I think that we're pretty confident that absent express language, there's not really a preemption or conflict issue. I at least want to bring that scenario out that there could be some issues with enforcement down the line. Sure.
So I wonder, and maybe you can ask Michelle to comment on this as well, is a reasonable response to a court that's going to hear such a case, well, look, this local ordinance has much lower fines. You know, it's a local ordinance, and therefore we have offered in the, you know, in the supporting documentation of our rules that we're perfectly willing to help employers to, you know, accomplish this task and give them resources. Is that something that might satisfy a court, and maybe we need to beef that up? Or are they strictly going to look at more of the text of the statute, do you think? And I don't know if you have an answer, or maybe Michelle has.
No, I'm writing it down.
Yeah, you know, because if we can, you know.
Or writing down the question.
Yeah, but if we can put in enough support to our materials that we give to employers to say, look, you know, we understand that this is something that smaller employers might have trouble with, and we're here to help and not, you know, come down on you about this, and show that to the court should the case come up and say, look, we offered to help these folks and give them all the resources they need, and so therefore they should be subject. Would that be enough?
You know, my first impression is one of the resources they need is time, right? I'm the owner-operator, and I've got to interview 15 people.
Right.
And I'm also the person who is the manager of the actual business. So I've got to take time away from the business in order to interview people. And that may never be qualified for the position.
That's right. And I mean, I guess I'm asking this sort of in terms of, is this done on a case-by-case basis by the court where if we, you know, end up with a case where the person says, look, this kind of position, I needed to have 15 applicants, and there's no way I'm going to be able to do interviews and on a time basis, that the court might come back and say, oh, well, okay, it's fine, Urbana, if you want to enforce this ordinance for less than 15 people, but you've got to make an exception for folks for whom the time is going to be too much or something like that. Are there mitigations that we can put in, or is the court going to simply say, look, no, 15 is out. You've got to change your ordinance. It just simply doesn't count. Is it going to be an up-down kind of thing by the court, or is it more nuanced, and do they do it case by case, I guess is my question.
Okay, so I'm sorry. The way I'm understanding this, the box to check is gone, right? Which is one of the educational pieces. I think we need to educate our citizens, because if you see that, don't check that, right? That's a start. If I'm an employer, what you were just saying, Pete, if I'm an employer and I don't have the time to interview 15 people, I won't. I will interview, I will look at the application. I'm just thinking about the school that I work for. We don't interview everybody. There isn't time to do that. You pick the top ones, and if you find your candidate out of there, you do, and then you do the background check, right?
Right.
The reality is you're not going to do 15 if you don't have time for that. I mean, I think that's kind of a moot issue in that sense. I really think people are smart. They're going to take the time that they need to meet the need that they have. I think my biggest concern was the box is now gone. And we're going to see applications out there, like if I went in today, that are still going to have that on there. And that worries me more than anything, because people don't know they're right yet, and I know we're going to do education on that, besides the employers being educated. Does that make sense? Okay. Thanks, Fran.
Yeah, no. I was just going to make the same, that, but also I have two concerns in the last statement in this memo. One has to do with the expense involved. Seems to me that things are always too expensive if you don't want to pay for them. And that's something, you know, especially the way corporations are behaving today and everything, that doesn't hold a lot of water with me. Also, how wealthy a corporation is doesn't always have to do with its size. You can have a small company that's very profitable. So I'm wondering about why we would even want to bring in that concept of additional expense. There may be some limiting factors, but I'm not sure it's a good idea to mention expense. I think it's a bit of a red herring, like the 15 interviews.
What I would say is this: the reason that I think she reviewed and that we discussed the expense is because that would probably be the basis for one of the arguments challenging our enforcement. And so we have to look at it.
Well, but maybe not a very good argument.
I think it depends. I think it's exactly what Peter was saying. It's going to depend on the individual circumstances and the question of whether or not a particularly difficult individual circumstance will ultimately invalidate the enforcement as a class. And that's sort of the unstated sort of concern. Although, you know, either we go for it with enforcement, and if we get a challenge, we spend the money and resources to defend the challenge, and it could go either way. And if it goes the other way, then we're no worse off than we were before, except for the resources and money that it took to defend the challenge.
Another thing is that, well, if this doesn't apply to 15 or fewer employees, is that go for the box as well?
In terms of the state, I think probably yes. Not in terms of the city, because ours is different.
Which leads me to my second point. This thing that says, going through all this trouble, et cetera, recruiting an individual who will be disqualified based upon the nature of their conviction and the nature of the position. Well, that's something that, in our way of looking at it, in terms of framing the enforcement rule and everything, is that that's something that we could never say will be disqualified, but only may be disqualified. And this seems to imply, I mean, if you know that ahead of time, that's something aren't we kind of discouraging the list? You know, that we're discouraging the box, but I think we're also discouraging the list of disqualifying convictions, because part of the procedures we've set up is to allow the person that has this potential liability now has the chance to refute that it rules them out. And this is kind of a like, oh, we know we're not going to hire this guy anyway sort of point of view, and that I think that's not our point of view, or one that we'd want to encourage.
Yeah, and again, I think it has to do with sort of legal scenario sort of building. And in fact, there will be some people, based upon information that's not known by the employer and may not even be known by the individual, right, at the beginning of the process, who ultimately will not be employable in particular positions. And I think that's what this is speaking to. So even though if you had perfect information at the beginning of the process, let's just say, right, everyone would know that from the beginning. But because, and it is sort of in a sense, an inevitability, right? But because you don't know and because that's veiled until you get further into the process, that's sort of what I guess the scenario is that there are some people that you're just not going to know about that, you're going to ferret it down from 15 to 5 to 3, and then you're going to ferret it, and then you're going to interview those 3 people, and at the end of that process, you go back and you say, oh, we can't hire this person. And that's that viewpoint in terms of the expense of the hire, or the expense of the process.
Right, but what I'm questioning, and I think this whole commission questions, is the idea of inevitability. That a person, even a person who has a criminal record for embezzlement, could possibly be hired at a bank because they know all the tricks or something, and they can help you. I mean, that's been known to happen. Yeah, but I'm saying that it's the idea that a certain just the fact of a certain conviction, period, disqualifies somebody. Just like saying that just because you're a female or just because you're anything else that we care about here is going to be an automatic disqualifier. And as far as I'm concerned, that should only be in places where there's like a federal law that is, an evidence-based federal law about, say, hiring pedophiles into teaching positions or something like that. I mean, there are definitely cases where that's applicable, but I think that what we're questioning is that whole idea of inevitability based on a simple conviction, that there's more to every story than that. So I don't know whether we feel strongly enough about that to want to risk litigation, but this does kind of eat away at our whole view of the matter, I think. Is that too strong?
One thing I'll say is this: when you're doing sort of objective, sort of legal analysis, you are trying your best to formulate arguments that the opposing party will formulate in the way that they will formulate them. And so, and that's just sort of a very practical, pragmatic way of thinking and analyzing your positioning.
I just want to make a quick comment based on what we've been talking about. I think one of the best things that we can do is use the educational opportunities to provide businesses with things like sample applications without the box, sample interview guides, a sample interview hiring process outline, flow chart. Like, I think one of the best things we can do is not assume that they're going to get these tools on their own. And since we're already going to take this opportunity to educate both citizens and businesses, we take it a step further and bring tools and process examples that would be successful within the ordinance to them as a way of saying, or even strategies. Like, if you have already, 10,000 applications that you've pre-printed and it has that box, take a black marker and mark, cross it out. Whatever strategies, but let's educate them in a process that makes them successful. Yes, I do believe, and I am completely in agreement with Todd, we have to think about what could come our way and what the other side is going to say about it. But I think we can also take that extra step and use the educational opportunity to go further than what we've done in the past, and not assume that they're going to make those connections themselves, but bring those connections to them. And I'm happy to help and create those templates and work with you on that workshop.
Any other questions on this? All right. Sort of going once, going twice. All right, great.
Good.
Can I get a quick point of order in regards to the agenda? It was my understanding that we only approved the last meeting's minutes, but we then have to approve the minutes from the meeting before, and I don't think we did that.
I think we did the omnibus.
Okay, I just didn't, I wanted to make sure that we did.
I mentioned both.
Okay, great. I
And call for that motion.
I was like, did we? And I couldn't tell, so good, thank you.
No, thanks.
And that's what our recording secretary has? Okay.
Thank you.
So in view of the other old business item, the union membership demographics, we've got letters that are drafted up and drawn up to go out with all of the ordinance language, so we just need to get those out. We've finally agreed on wording. That's ready. In terms of the EEO contract compliance program, I'm just giving this to you for your consideration for next month. But we've given you pages 7 through 11 of the EEO contract compliance rules and procedures. If you'll notice on the second page, on page 8, there is underlying text there. And that's generally, or at least part of the text that we're going to change. I think I've got to make one change above this, but this is generally describing the Urbana Disadvantaged Business Enterprise list. And this will be the list that if you go to the compliance plan on the very last page, the very last item, basically it lists as one of the good faith efforts, utilization of one or more subcontractors identified on Urbana's list of Urbana Disadvantaged Business Enterprises. While the city makes no express or implied warranties regarding the performance of these contractors or the contractors on the list, the Human Relations Commission will recognize such utilization as a significant good faith effort. So that's sort of them put together, and that's sort of what we were thinking in terms of this process.
So review this and we'll talk about it next month?
Yes, and in fact, we'll send out an electronic copy for everybody. So.
Great, thank you. No new business, so should we move to your staff report, Todd?
Sure. If you look at the monthly complaint activity report, we've actually only had a couple of different inquiries.
We've got approvals to do first, don't we?
Oh, sorry. Yeah, I do start with approvals, don't I? All right. We've got several approvals here. I will tell you that there were a couple that we, particularly Growmark, that we had some conversation about in terms of their numbers, because they're looking not great. There's been, I guess you could characterize that as some improvement, but not a whole lot.
0.0.
And so we basically did the minimum there. However, we would totally understand it if you decided to go for it with a review of that. The other one that was concerning,
Baker Tilly?
yeah, Baker Tilly.
The question I had about Baker Tilly, it looks like this is an accounting firm in Chicago. Is this a contract that Baker Tilly has already gotten the bid but is waiting on this particular review to go forward, or are they just bidding on a contract right now?
No, I believe that they are in process. If they haven't already been awarded it, I believe that they're moving forward with the award. So,
Yeah, their numbers are interesting. I just want to say, and please do minute this, that if we could split out, one of the vendors down at the bottom is Michael Scott and Associates. Mike was a neighbor of mine for many years and is actually my current landscaper, and so I'm going to abstain from any discussion of that. So if we could split the motion when we get to that, so I don't have to vote on it, it would probably be appropriate.
Thank you for pointing that out.
Any questions on these?
And Growmark is another that probably has a current contract. Is that true?
They are a fuel provider, and to be quite honest with you, I think we have other bidders there. I think typically they have been the low bidder. And I think they provide some tools also, but I think primarily the bulk of the money that we spend with them, at least I think, is on fuel. Yeah, so they were formerly Illini FNS or FS.
Do we need a motion to discuss?
We do.
So,
This is where it gets complicated.
why don't we do the easy ones first? Well, actually, I guess before I make the motion, so we don't waste everybody's time, my inclination is that we ask for a review of Growmark, given the state that they're in. I have less concerns about Baker Tilly. I'm glad to see the 6 months. I think we should send out the letter. I think we should
Yes.
monitor it. It's a new company. They can give us some more background in those 6 months of what they're doing. And so I think it's reasonable
The
to go ahead.
10%, I mean,
Right.
but
I
it's
mean,
Chicago.
it's
That's not
Chicago.
good.
It's an accounting
I
firm.
mean, 6 months, get there.
And finding out what that means and
Yeah.
what efforts they've made, I think 6 months is all we're going to be able to do
Yeah,
there.
I agree.
But it's a good,
So given that I'm seeing nods, let me make a motion leaving out the two that are problematic for me. So I would move that we approve the following staff recommendations: Baker Tilly, Virchow, Kraus for 6 months, Enterprise Rent-A-Car for 1 year, Illini Concrete Raising for 2 years, United Fuel for 2 years, Burtness Engineering Services for 2 years, Chris and Company for 2 years. Is it Koenig Body and Equipment for 1 year, or Koenig? Koenig. Depends on how German they want to be, I suppose. And Visu Sewer for 1 year. Move approval of those.
I second.
discussion. Any questions, comments, observations?
I agree with Peter's observations.
Okay. All those in favor, please say aye.
Aye.
Opposed, the same? Thank you.
Someone else gets to make the motion for Mike Scott.
Okay. I mean, yeah, total number of 5, I mean, but yes. Is there a motion for Mike Scott, please?
I'll make a
Approval for
motion.
2 years?
I move that we approve Michael Scott and Associates Incorporated for 2 years.
Thank you. Is there a second?
I second.
All those in favor, please say aye.
Aye.
Opposed, the same? Okay.
Growmark.
Growmark.
So what information do you have from them already, Todd?
You know, they've actually provided.
Real quick, are we talking like a lot, Illinois FS, like out on University Avenue?
Yeah.
Is now called, okay.
They've actually provided a substantial amount.
I think it's a DBA.
Yeah.
Did we put this out on the website, or? Yeah, so out on the website, you'll find quite a bit of information that they've provided on their good faith efforts towards, compliance. And so they've provided a narrative account, that is reasonably sort of comprehensive. And this is a company, I believe in the past, who has received information from us on, for instance, the compliance plan spreadsheet that we have. And so they've laid it out very much in accordance with that. But if you have not read it and have not had a chance to review it, then I guess my recommendation at this point would be, why don't we
Defer
review
this
it and then come back and vote?
Could you give us a quick snapshot of your assessment of their good faith efforts?
To be quite honest with you, the reason we we believe that they, and that's one of the reasons I prefaced it early on, but we believe that they have provided a reasonable demonstration of good faith efforts. Or documentation of reasonable.
So do we need a motion to table it to next month, or can we just,
I think it'll just show up and no one makes a motion.
okay?
I think if we don't make a motion to approve it now,
Okay.
Todd will likely bring it back next month, will he not?
Todd, will that help? Is that okay with you?
So what I want to remind everybody is it is out on the website. We didn't want to send it to everyone because it's substantial.
It's,
And
Yeah.
most of your emails, if you have non-commercial email, probably would have just kicked it back to us anyway. So have a look at that and
Okay.
we'll take another run at it next time.
Yeah, they do have like it all listed.
as age is creeping up on me, Tony, would you mind reminding us in your email to check that out? A month is a long time for me. I will probably forget unless I do it right after the meeting.
It's 120 pages, folks.
I'm
Oh.
sorry to ask, but.
What I just read was 3. Oh, no, it keeps going.
It goes on and on.
No, it's easy.
We had problems condensing the files. Normally we can reduce the size of it. Tony sort of played all of his magic
It-
tricks and was
It's
not
got
able.
color photos in it which don't compress really well if they're already compressed,
Yeah.
so, yeah.
No, that's a great, good use of the website too.
So-
So did we, I think that covered, all right. Todd, should we move forward to our recent activity report, please?
Sure. And so, as I was saying before, when I got the order wrong, there have been, I believe, 2 substantial contacts since the last time we talked. I had actually another one yesterday evening, so that'll be reflected on next month's activity report. Any questions on these? Okay, moving on to the case logs. UC 130709, that is a probable.
One quick question,
Sure,
sorry.
I'm sorry.
There was a housing resolved this past month?
Yes.
What does resolved mean in this context?
Resolved means, specifically in the context of housing, that the individual was able to resolve things with their landlord such that they were able to sort of do whatever they needed to do. So it was
So the complaint was
specifically in the
withdrawn
area of
because
housing.
it was resolved
Yeah.
between the parties?
And again, the housing ones get resolved quickly.
Sure.
As opposed to the employment ones, which are much more complex.
Sure.
So when we say it's resolved in housing, 99% of the time, it is the individual either got out of the lease, the individual got the repair that was needed to be done, that they felt that they were being discriminatorily withheld from or deprived of or whatever. So that, specifically in housing, that's what resolved typically means. And if it's not that, then I'll note it.
Thank you.
Okay, I'm sorry. Any other questions?
So we had a no probable cause finding?
Yes, we have not published the no probable cause finding yet, but that will be going out. I write these up a week in advance, anticipating what will be completed, and that is not. We're initiating a legal review of an initial determination. It's a complicated case, so it's going to take a bit of legal review. It's a very interesting case, though. And then finally, there's also a public accommodation. Both of these cases are very strange. They're very out of the ordinary, and it's just going to take some time, and we have not been able to complete those reviews yet. So I'll just be quite upfront about that.
And are 2 cases which we expected to go away, that,
Well, we have the one individual with the 2.
yes.
Yeah. So I have not heard back, but to be quite honest with you, the other sort of priorities that we've been dealing with.
Right.
And again, I'll just stress this. When you've got lawyers on both sides who are all kind of telling you, we've got this under control, and it's in the hands of the lawyers, there will be a time, and there can be times when we can expend resources and say, hey, we're going to track this down, we're going to track this down, we're going to pay our people to go. But to be quite honest with you, this was not the month for that. So
And then finally, our budget looks pretty similar.
yeah, Tony has highlighted that there are no changes since the previous report.
Thank you for the staff report. Are there any final announcements or announcements? Anything for the community to know this month or in the near future?
I think the only announcement, just to put it out there for everyone, that I believe it's October 19th is the deadline for the Martin Luther King nominations.
Yeah.
So get them in.
And we've got one so far.
You'll have two.
We're anticipating having more. So
Todd, you will inform us of what you need from us for our educational seminars coming
yes,
up?
yeah. First of all, we're going to try to get someone from the state down here to authoritatively speak on the act, although I'm assuming they may be pretty busy, but we'll at least make the attempt. And if we can't get someone, then we'll get someone who's at least feels well-versed enough to provide a decent presentation on our behalf.
Great. Okay. Thank you all. Have a great night. We'll see you next month. Meeting adjourned.